The first case to come before us this morning is State of Ohio versus Gerald Dolcini. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. And if you're the appellant, if you would let me know when you get started, I'm keeping track of the clock this morning and can let you know if you're eating into any of that reserved time. The arguments are being live streamed, actually. A recording will be posted on the court's YouTube channel. Please don't use the names of any children or victims during your argument. I don't know that that's all that relevant to this case. However, as I just mentioned, these arguments are being recorded and will be posted. We've read your briefs. We're ready to proceed when you are.
Thank you very much, Your Honor, and good morning. And
Good morning.
If it pleases the court, my name is Alan Medvick. I am here as attorney for the appellant and defendant in this matter, Mr. Gerald Dolcini. We are here having raised 3 assignments of error regarding the court's decision in this matter, finding my client guilty of 2 counts of littering. Those assignments of error are insufficiency of the evidence, manifest weight of the evidence, and a error in not dismissing this case as a violation of my client's First Amendment freedom of speech rights. We'll start with the sufficiency and manifest weight arguments, although I think they're all well tied together. My client was distributing literature to neighbors of his in the city of Hinckley, in the village of Hinckley, material that he would put together himself from magazine articles and other materials that he had. Some of them were handwritten, some of them were cut out articles. He would remove his own name from delivery from magazine subscriptions that he had and would bind these things together and send them. He would put them together into a packet and drop them off in the yards of neighbors with whom I think he admits he was politically not aligned with, who were actually political opponents of his. He is a staunch a left-leaning liberal, and these were folks who still had Trump signs in their yard post-election, post-January 6th. And
explain exactly what the packets were like. Were they, bound up by a rubber band? Were they in a bag? How were they collected?
And he would wrap them in plastic, often sheets of plastic he would cut himself, and then would bind that with a rubber band and distribute those materials and put them on the ground. He was not flinging them into the yard. He was not crumpling up papers and distributing
Were they up by a door or by a mailbox, or just kind of sitting somewhere in the yard?
I think they were put in the yard or by a mail. They were by the mailbox, is I believe what the testimony will show from the transcripts. And I would argue that the statute requires that litter be, while paper is included among the broad definitions of litter, garbage, trash, waste, etc., it must be of an unsightly or unsanitary nature. And I do not know that, and I know that these things did not rise to that level. This was not garbage. This was material specifically distributed to evoke a response. It was unquestionably material my client was delivering to be read, not to be gotten rid of. He was not discarding this material. It was by all definitions, by any realistic definition, it was literature, not litter. The state provides definitions from Merriam-Webster regarding trash, rubbish, garbage, waste. Trash being something worth little or nothing, empty talk, something of crumbled or broken condition. Rubbish defined as both trash or useless waste in a rejected manner. Garbage, unwanted or useless material. Waste as items discarded as worthless or of no use. These items do not fit in with any of those definitions. These were clients that my client considered to be of use, as he said, to inform, to entertain, and to annoy. Now, whether those are, it's not a question of whether those are appropriate uses. They are uses, and this is why all of this is tied together under a First Amendment banner. This is literature that was meant to offend, and one of the central tenets of freedom of speech is this freedom to offend. And that this was not the most orthodox of means of distribution, that many of these things, as I said, were handwritten. My client is of limited means and was distributing things on his own dime and doing this in the best and most efficient way he could possibly do so. Also with an eye toward reuse of some of the plastic materials. And so this would not litter. The court comes back to the strict liability language in the statute of regardless of intent. And that's in my reading of the statute, that is a statement of a lack of mens rea, that this is not a reckless act. This is, I think that is meant to say, I meant to throw it in the garbage can, but I missed, and now I am littering. That is where that is. This was to turn what was the intentional distribution of material, and it was of political nature, into a littering charge, I think is a stretch. I don't know that and I think under this, just as a matter of sufficiency, I don't think that this material fits within the definition of litter. And I think that regarding a manifest weight, my client testified as to what he had done. He provided evidence and information as to why and how he had put these packets together. And that evidence was that he was putting these packets together with intent. He was delivering them with intent. He was not wasting anything. He was not throwing these things away. He was providing these things again with the intent to either first, in the hopes of, I think, changing the minds of the people he was distributing it to, or second, to let them know that he felt differently and there were other people out there who did so. And if they became offended with that feeling, with that knowledge, that's on them. That's not a criminal offense and certainly not littering. And which ties us all back to the First Amendment, that we're dealing with the freedom of speech issue here. We've been talking about, you're muted, Judge. Are you trying, Judge Lansinger? Did you have, okay, thank you. There's a line of cases that were cited throughout in the briefs and and at the trial level, on the motion level, stemming from Martin v. Struthers to the 9th District case of Molyneux, which regarded handbills on cars, and Reddy, which regarded newspapers, that it is not a requirement that you have permission or that you even know the person distributing the handbills or the information to the house. There's no requirement that my client provide his name, that he leave his address and information on there. There is no requirement that he not distribute these things in an anonymous manner. And I think that that case law is out there. And I would point to the state's use of Job out of California, Job versus Caldwell, I believe. A Sixth Circuit case, I'm sorry, it's not a sixth, that is more recent and seems to go the other way. I would point out first that while the state wants to call it a new, argues that Molyneux binding precedent out of this district is not the last word, I would indicate that Job is also not the last word. The Ninth Circuit expressly disapproved of the holding in Job in San Clemente, or Klein versus San Clemente, 584 Federal 3rd 1196, holding that there is no requirement that you make a public, that there be a notification, that you identify yourself, or that you give a right of first refusal to the homeowner in the distribution of handbills. That case points to an older case of Van Nuys versus City of Thousand Oaks, which is expressly a littering case. It's much older, but it is reaffirmed in San Clemente, and it holds that, and San Clemente reaffirms that the posting of a general no solicitations, no handbills, warning and notice is sufficient to protect those homeowners' rights, and does not require specific identification of a person distributing materials to a home. And that is the support throughout this line of cases, that the this, and let's be clear, this was a political decision. And when you read the testimony of the witnesses, it'll be clear that they were not offended by the nature of the materials in their yards. They were by the paper. They were offended by the content. When they reference garbage, it's clear on cross that what they mean is the words on the page, not the page itself. And this was a wrongly decided case, and it was expressly pursued on First Amendment on grounds of political nature and in violation of free speech. And as such, the court erred in not granting and not denying this on First Amendment grounds, and in finding that these materials were litter. So I don't know where I am for time.
Counsel, you have 5 minutes remaining.
That's about where I wanted to be.
Okay, does the
Thank you.
bench have any questions
And I
before?
apologize if I forgot to ask for 5 minutes.
That's okay,
I have a question.
certainly.
Going back to sufficiency, unsightly and unsanitary, there was some testimony in the trial about it being COVID times, and that's why it's unsanitary. Do you have a response to that?
I think at that point in the time of this was going on, I think we had reached a point where we were also well aware that COVID was an airborne virus, and that was not a likely outcome. And I think that is to be honest, it's a retrofitted attempt to find unsightliness or unsanitariness. I don't believe that this is a circumstance where these materials were, he wasn't shoving them in anyone's face without a mask on. He wasn't trying to spread that virus. I think that the distribution of these materials, especially in an outside environment, would not create a health risk. And there was no, while probably not objected to at the trial level, this was not there was no expert testimony that this created a risk of harm under even in in that height of COVID and the pandemic and lockdown. So I would hold on to the rest of my time for rebuttal at this point.
Thank you, counsel. Attorney Huber,
Beg pardon?
you're up.
Please the court. My name is Greg Huber, represent the state of Ohio. I also tried this littering case. The appellant's first two arguments on manifest weight and sufficiency essentially both involve how the court looks at what was dumped in people's yards and compares it to the definition of litter. In my brief, I did point out that there is no specific definition of trash or garbage, and that the court would appropriately look at to the common sense or common dictionary definitions. From this side of the aisle, we would respectfully assert that these papers and materials that were wrapped up and dropped off in people's yards by Mr. Dolcini, in fact, meet the definition of litter. If you read the transcript of the people who complained, you come to understand that these two individuals were just two of many individuals that the Hinckley Police Department received complaints about with respect to what Mr. Dolcini was doing. He gathered these papers, he cut out any information that would relate to where these papers came from. If you look at the material themselves, they're rather disjointed. Some of them are handwritten notes from Mr. Dolcini. All of them have holes cut in them so that he cannot be identified as the person delivering these papers. The people who received them didn't know what to do because they didn't want them and didn't know where to complain. The police department had to go to the post office and have barcodes analyzed to figure out where this was coming from. And that kind of activity, I think, takes this case a little farther than Molyneux or some of the other First Amendment cases, because this defendant appellant is actively trying to conceal any methodology of figuring out who is dumping this stuff off in the yard of these people who were complainants.
Is there some different restrictions for anonymous versus non-anonymous political speech?
Well, if you look at under the First Amendment analysis, there is in the Martin versus Struthers case, there is a balancing of the interest of the person speaking or attempting to deliver literature as compared to the person who receives it. And if it involves personal property, the least amount of protection is afforded under the First Amendment. And where this individual is actively cutting out all of the papers that are in these plastic bags and leaving them with big holes that leave out his address or any contact information, so that you have no ability to know where this stuff is coming from.
If it's just a nice, wonderfully printed sheet that said, I don't like Donald Trump and you shouldn't either, and it didn't have any indication of who it came from, would that still be a problem?
I think it ought to have some kind of identification on it if there is to be a balance with respect to these issues. And it's the striking of the balance of these issues that the Sixth Circuit Court of Appeals addressed in the case I cited in my brief. I think, at least under the Sixth Circuit Court of Appeals analysis, if there's somebody actively trying to conceal what they're doing and cutting holes in the material and leaving it on your car, I think it takes it outside of the Molyneux case, which this court ruled on previously. And I think there ought to be some protections for private property owners receiving this, especially when this is dropped in your yard. There was testimony that this was packaged up by Mr. Dolcini. It became unpackaged, blew all over the yard a few times. People had to pick this stuff up. And had no recourse. They, even in the papers dropped off from the free press, you still have some ability to direct what's happening because you have somebody to respond to. In this case, if you look at these materials, you would have no ability to know who's sending this stuff to you or even object to how it's being thrown in your yard. Rubber band comes undone. You don't catch it in time, the wind gets it, it's blowing around the earth. There's just things about this case that go farther than some of the other cases that this court has looked at and other cases that I looked at in examining the First Amendment issue. I think there needs to be some balance, but where you're doing—
I have a question.
Yes, Judge.
If a campaign volunteer from any campaign who's anonymous comes and brings a piece of literature onto any porch or any private property, couldn't they then be charged with littering? Isn't this the same fact pattern, except for maybe Mr. Dolcini had his more near to the mailbox on private property? Wouldn't that be curbing any political speech if we said this is littering, if that was the case?
Well, if you read the Sixth Circuit's more recent decision on this, I think there needs to be some ability on the part of the private property owner to address the person who is delivering this stuff to your house. And frankly, most of the—
Would it appropriately be a littering charge though, or would it be something like notifying a person who goes on private property to stop coming on private property, like a trespass? I mean, littering could be a one-time event where someone comes to your porch and puts down some political material, which happens all the time.
Well, if I'm going to put these materials on your property without your knowledge and walk away, and I don't package them so that they're staying together, they didn't, and I have holes that I've cut in this material, you have to look at this stuff. And as judges, I think some deference needs to be given to the people who received this. Each of these complainants individually characterized this as garbage or unsightly, unsanitary, They didn't want it and had no ability to do anything about it. It was thrown in their yard and was happening repeatedly in the area where Mr. Dolcini did this. If you're cutting out, making holes in this, scribbling on it with notes, this meets the definition of litter. And I think the people who receive it ought to be the ones who define that, not Mr. Dolcini. I think deference needs to be given to the trial judge who actually looked at this and, as a matter of fact, in his own determination, found it to be litter. I think deference needs to be given to the people who have to deal with this and look at it and describe the cutout holes, the scribbling on it. The material itself is disjointed. It's not necessarily connected. There's issues that go from wildlife to climate change to Donald Trump and other culture war issues that are in these materials. These people who received this each testified these materials as being unsightly, unsanitary, and garbage, and they didn't want it, and they didn't know where to go.
Counsel, you would say that the appellant's characterization of their testimony that they were just talking about the content of the speech is garbage. You would not agree with that. They were talking about the way this was packaged, presented to them as garbage.
No, if you read the transcript, these people and the way they testified, the way it was delivered, the way it was came undone for the one lady in particular, the transcript reveals that it's more than just the content. And I know Mr. Dolcini wants to narrow it to that, but that's not what happened. And that's the way the trial judge took it. That's the way I took it when I tried the case. These people thought this was garbage.
Are there any exhibits that show how this was packaged together?
We introduced the packets themselves. In my brief, I indicated the exhibit numbers.
Okay.
I think the exhibits are
Thank you, Mr. Huber. If you've identified those, then there's an actual package we could look at in the exhibit. Thank you.
and I guess at the end of the day, the appellate court will have to look at these exhibits, examine them. If the appellate court feels that this does not meet the definition of litter, then the state of Ohio stands corrected. The people who received the stuff thought it was litter. The trial judge looked at it, received it in evidence. He thought it was litter. So did I. I thought the manner in which these materials are defaced with the cutting and the holes is a differentiating fact from simply getting a political sheet delivered to your porch. I've received political sheets delivered to my property. I thought this was different because of the way they were defaced and altered by the defendant appellant. I also thought that these alterations take the situation away from the property owner from having any ability to respond to this, which I think upsets the balance called for in the First Amendment analysis. And for these reasons, we brought these people to court. Mr. Dolcini obviously disagreed. The trial judge looked at these exhibits. He felt it was litter. The complainants certainly did, and they weren't the only ones that the Hinckley Police Department had to deal with. And I think Mr. Dolcini needs to handle this in a different way if, in fact, he wants to engage people with respect to his political views. And for that reason, we brought the case to court. The trial court agreed with us. Obviously, if this court doesn't agree with us, you're going to tell us, so we'll stand corrected.
Thank you, counsel. Attorney Medvick, please give me a moment to reset the clock, but you'll have 4 minutes and 15 seconds remaining.
Thank you very much, Your Honor.
Okay, you may
Thank
proceed.
you. I think the state's struck on a lot of things that make it quite clear why this was not a litter. First of all, my client was distributing these materials on broad-based basis by the state's own statements. He was distributing literature further than just to these two houses. He was acting as a means of distributing his opinion. The suggestion that litter is defined in the eyes of the beholder, I think, is a little absurd. There's a statutory definition for that, which does not fit within, which these materials do not fit within. The fact that my client cut out his name from the identifying materials, we've talked about them. That's not a requirement that he identify himself in these distributions. It's quite clear that they did find him. They did not warn him that he needed to stop these materials and that these folks did not want this. They simply proceeded with the littering charge, which is, I believe, one way they could have addressed that these, that the city of Medina, the village of Hinckley, the homeowners themselves could have posted no bills. They could have told my client specifically that he was not welcome to distribute materials there. They did not take those actions. They did not give my client any warning. And it still would not have been a litter. Like that point, it likely would have been a trespass or some other violation. But this is still not litter, however you want to define it. And I think Judge Landinger struck on the slippery slope concerns, that there is especially if you are leaving the definition of litter to the homeowner and to what the content of these materials are, it is becomes very concerning. And this is why this is a significant First Amendment case, even though it is a misdemeanor littering case. We are talking about the distribution of political materials, handbills, and the distribution of handbills to private property. I think that's language specifically in the Van Nuys case that while public streets, parks, and public places have often been characterized as traditional grounds of free expression, house-to-house distribution of written materials constitutes one of the principal means of implementing First Amendment rights of communication. And they have historically been afforded constitutional protection for such distribution. I think that's what we're dealing with here. It's unquestionable that the material here was not thrown about willy-nilly. This was not discarded material. This was delivered material. These were packages that were sent to the specific persons. This was done with the intent to promote and distribute material. It was not litter. And we're attempting to turn, and the state that is attempting to turn something, to perform alchemy and turn these materials into, to fit within a statute and to weaponize the littering statute as a means to try to freeze this speech and to prevent Mr. Dolcini from, as the prosecutor said, from getting his word across in this manner. I think that the statements of the prosecutor support the finding that this is not litter, and that it was in fact being distributed with the intent by Mr. Dolcini to promote his message. And he has been punished and cited for that. So with that, if there are no questions, I would cede the balance of my time. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision which will be mailed to the parties by the clerk of courts on the day that it is issued, as well as posted on the Ohio Supreme Court website. Thank you again. Have a great day, gentlemen.
Thank you.